Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain the eviction laws in Kansas and outline 5 simple steps landlords can take to initiate an eviction. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks on a property or physically remove a tenant from that property. So if the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the court. This is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve a court in this process. In this video, we'll talk about what the eviction process looks like, Kansas laws that determine how evictions are handled, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice. When a tenant in Kansas breaches the terms of a lease agreement, a landlord can serve the tenant with what's known as a notice to quit. There are various versions of this form, and each is designed for a different situation. The first is a 3-day notice to quit for non-payment, which is used when a tenant fails to pay rent. This notice is used for tenancies of less than 3 months and orders the tenant that they either pay the rent within the 3 days or face being evicted. The second is a 10-day notice to quit for non-payment, which is also used when a tenant fails to pay rent but provides a longer grace period. This is used for tenancies of 3 months or longer and gives the tenant 10 days to pay or vacate. A lease agreement in the state of Kansas may also establish a different grace period. It's also worth noting that Kansas law says landlords may begin charging a late fee the day after rent is due, even if the notice to quit is being served. Another version is the 14-day notice to quit for non-compliance. This is used when the tenant violates the lease in some way that's unrelated to paying rent and gives the tenant 14 days to correct the violation. An example could be getting rid of an unauthorized pet. If the tenant does not fix the problem, eviction proceedings can begin after 30 days. There's also a 30-day notice to quit for second non-compliance. This is given to a tenant who has violated the lease agreement in the same manner twice in 6 months. In this case, there is no option for the tenant to remediate. The notice to quit orders the tenant to move out within 30 days. There's another form called a 30-day notice to quit. This one gets used in month-to-month tenancies. Landlords and tenants must use it to provide 30 days notice before terminating the lease. One of these notices must be delivered to the tenant in person. If the tenant cannot be found, the notice can be posted in a conspicuous place on the property or mailed via certified mail with a return receipt request. If mailed, 2 days are added to the time frame specified in the notice. If the tenant fails to respond to the notice, then the landlord may begin eviction proceedings. The landlord does this by completing 2 forms known as the Civil Information Sheet and the Petition for Eviction. 2 copies should be made of each form, as these will be served on the tenant. The petition for eviction must be signed by the landlord in the presence of a notary public. All forms must be filed in the district court of the county where the property is located. Filing fees will depend on the jurisdiction. Once all forms have been filed, the landlord must obtain a form known as a summons from the clerk. The summons will set a hearing date. A copy of the summons must be served on the tenant along with a copy of the petition for eviction. Both forms must be served on the tenant by the county sheriff. If the judge rules in the landlord's favor, the landlord must complete a form known as the Journal Entry of Judgment and send it to the tenant along with a certificate of service confirming the judgment was received. This orders the tenant to move out. If after being served with the judgment, the tenant still refuses to vacate the premises, the landlord can file a writ of restitution. This form authorizes the county sheriff to remove the tenant and the tenant's possessions from the property. We've got everything you need to get eviction proceedings going, from eviction notices to court documents, and you can access all of them at the link below for free.